Hello, Assalamu alaikum, and good evening. Welcome to the Ask Aman Livestream. Today we've got two very interesting subject matters for you. And before we go to those, I'll just quickly play a couple of the introductory videos, so bear with me.
Aman Solicitors Advocates. From our offices in London and Luton, we represent clients across England and Wales. We specialise in civil and commercial law and litigation, divorce, child custody, contact and family law, all areas of personal injury, accidents at work, trips and slips, family and business immigration, nationality, asylum, deportation and detention law, wills and probate, employment law for employees or employers, charity law and disputes, public and regulatory law. Our professional and committed legal team will provide you with a first-class and competitively priced service. Aman Solicitors Advocates, your firm of choice.
Welcome back. Before we go to the first feature, which is the Supreme Court judgment in the Uber case. This case has huge implications not only for minicab drivers who are working for Uber, but generally regarding the law of employment or self-employment. And we will explain in detail how this all works. But prior to that, just a small disclaimer. Thank you very much. So I'm going to bring in my colleague Saad Saeed, who will be talking about employment law in the light of the judgment of the Supreme Court of the United Kingdom in the Uber case. Assalamu alaikum, Saad. Thank you very much for joining us, and it's all over to you.
Wa alaikum assalam, Bashar. Thank you very much. And good evening to everybody watching out there. Okay, so those who are keeping up to date with the news may have been aware that on Friday, the Supreme Court gave a judgment in the what we'd call the Uber case, where a number of drivers challenged Uber and said effectively that under the eyes of the law, they are workers and they are not self-employed people. And the implication of that is that if they were found to be workers, which indeed the Supreme Court did find them to be, then they were able to have various rights in law, such as being paid the national minimum wage, being paid annual leave, and other workers' rights, such as under the working time regulations and part-time working regulations. So start off with a little bit of a background to this case before we got to the Supreme Court. So as people will be aware with Uber, the way that it operates is that it's a company which offers what we will say are minicab services. I mean, minicab services is not the correct legal term, but let's say private hire vehicles. And you can hail a ride to take you anywhere that you want using the app, and the company through the app, Uber, will arrange that for you. So the way that it was set up is that Uber have contracts with the customers who are looking for a ride to take them from place A to place B. They have separate contracts with their drivers, but there's no direct contract between the driver and the customer, or the paying customer, as we will call them. And this arrangement, although not unusual, was set up in such a way in which Uber said that the people that they use to provide the services of the rides to customers are all self-employed. So as I said, going back to the beginning, a number of drivers that work for Uber thought this was not right, and they were actually workers under the law. They weren't actually self-employed people, and they claimed that they had rights, especially the right to the national minimum wage. And so they took Uber to the Employment Tribunal back in 2016, where this case was first considered. Now, when the Employment Tribunal considered the case in 2016, after a long analysis, they did find, in fact, that the drivers that were working for Uber fell under the definition of being workers under the law, and so they were entitled to rights such as the national minimum wage, paid annual leave, and others, such as under the working time regulations. Uber then not agreeing with that decision, appealed to the Employment Appeal Tribunal, and in 2017, the Employment Appeal Tribunal agreed with the judgment of the Employment Tribunal and again held that the drivers that work for Uber are workers. Again, Uber appealed against this to the Court of Appeal, again challenging both of the decisions of the Employment Tribunal and the Employment Appeal Tribunal. And the Court of Appeal held by a majority of 2 judges to 1 that the Employment Tribunal and Employment Appeal Tribunal were both correct in their assessment, and indeed that people working for Uber as drivers were workers. But because it was a split decision, so 2 judges agreed that they were workers and 1 judge did not agree that they were workers, then they gave permission to appeal to the Supreme Court. And as I said before, the Supreme Court issued its judgment on Friday morning. And essentially, they found, or they agreed with all of the courts below. They agreed with the Employment Tribunal, they agreed with the Employment Appeal Tribunal, and they agreed with the Court of Appeal, the majority in the Court of Appeal, that people working for Uber as drivers are indeed workers under the law of the UK. Now, in order to understand why the Supreme Court decided people working as drivers for Uber were indeed workers, it's important for us to look at the reasoning given by the Court of Appeal, by the Supreme Court, sorry, for reaching its decision. And they identified 5 very important aspects which they thought were worth highlighting in their judgment, which effectively made them decide that the drivers for Uber are workers. What are those 5 factors? Well, first of all, the Supreme Court looked at the way that the drivers were paid by Uber for the work that they did. And they said that the amount paid by Uber is fixed by Uber, and that the drivers have no say whatsoever in how much they are paid, other than by choosing when and how much work that they do. So the implication of that was that every time they agreed, a driver would agree to accept a request, the amount that they would be paid was fixed by Uber. The Supreme Court found this to be quite important because it highlighted the lack of choice that the drivers had in terms of setting their own rates and how much they were being paid. Now, it is also important that the drivers were not permitted to charge more than the fare that Uber would quote the customer on their apps. They could obviously charge a little bit less or less if they wanted to. However, Uber would fix the fee that it charged the driver. So if the driver would then charge less to the actual customer than the quoted fare, they would lose out themselves on how much money they were getting, because the fee that they would pay to Uber or the fee that Uber would take out of that fare would remain the same no matter what. And Uber also retained discretion as to whether to make a full or partial refund to any customer who complained about their journey. So all of this was outside of the control of the driver, and the Supreme Court found that important. Secondly, the Supreme Court said that the contractual terms on which the drivers performed their services were all dictated by Uber. So when a driver prospectively wanted to work for Uber, they would be given or offered a contract which contained various terms and conditions, and effectively it was a take it or leave it offer. The drivers had no say in amending the terms and conditions at all, or deleting any of the terms and conditions. And so effectively those terms and conditions were imposed upon them by Uber. Again, the Supreme Court found this relevant and important because it highlighted the lack of control that the drivers had when they initially entered into their relationship with Uber. Third, the Supreme Court then said that although drivers have the freedom to choose when and where they want to work, that is obviously within the area covered by their licenses, once a driver had actually logged into the app to begin work, then the driver's choice about whether to accept requests was actually constrained by Uber. So again, there was a lack of choice, overall choice for the drivers. The Supreme Court said that the drivers are not under any regulatory obligation to accept such requests, and that Uber actually retained an absolute discretion whether to accept or decline any request for a ride. And what the Supreme Court did here was contrast that situation with taxi drivers in London, let's say, because taxi drivers in London are covered by regulations where there are laws setting out whether they can accept rides or not, whereas for Uber drivers, they had no such choice once Uber had decided to accept a request for a ride or even to decline the request for a ride. So the simple fact was that where a ride is offered to a driver through the app, Uber exercises control over the acceptance of the request by the driver in two ways. One, they control the information which was then passed to the driver or provided to the driver. And secondly, they also exercise control by monitoring the driver's rate of acceptance or cancellation of the requests. Now again, this was important. Why? Because the Supreme Court said it shows the amount of control which Uber has over the drivers who were claiming that they were workers. Now, the consequences of a low acceptance rate by a driver was that these rates would be monitored by Uber, and if and when the acceptance rate fell below a certain level, then it could lead to the driver not being allowed to accept further work or rides, because what Uber would do is that it would automatically log them off the Uber app, and when they were logged off the Uber app, then the driver was unable to log back on for 10 minutes, and during that time they could not accept any rides being offered at all. Now, in the internal documentation that Uber had, which was shown to the Supreme Court in this case, Uber itself described this as a penalty. And that was also important because if Uber was able to penalize the drivers, again, it exercised some form of control that they had over the drivers. And I keep on coming back to control, and you see that this is an overriding theme in the judgment, and I'll explain why towards the end. Now, the fourth thing that the Supreme Court found significant was the way in which Uber controlled the way in which the drivers actually delivered their services. So what do we mean by that? Well, what we mean is this. Drivers had to provide their own car, and that meant obviously that they had more control themselves than other employees would over the physical equipment used to perform their work. Take, for example, somebody who works on a building site, the building tools are maybe provided by their employer. That wasn't the case here. However, the Supreme Court went on to say that although the drivers provide their own cars, what Uber did would be that they would vet the type of car that was used, and they would make sure that there were requirements to be met. So the car had to be a certain color, or the car had to be not older than a certain number of years. So not any car could do. So again, Uber retained some control over what cars the drivers could use. Also, the technology which Uber used was absolutely integral to the service, and that technology was wholly owned and controlled by Uber. So drivers had no means of working unless they used that technology. And the Supreme Court said this is yet another example of how Uber exercised control over their drivers. And so they said then, although it's not, they also highlighted that using the app, when the driver uses the app, there is a recommended route given on the app for the driver to follow. And although it was not compulsory for the drivers to follow that route, if a different route was indeed followed, customers could complain, and any driver who did not follow the route suggested by the app risked the consequences of any financial penalties imposed as a result of that, which the passenger had not approved. So again, like I said, the way that the technology was used by Uber controlled many facets of the way that their drivers worked. Now, the other way in which the technology was used was by use of a rating system. So if you've ever used Uber, you'll know that after you've had your ride, you would be asked to rate the driver and the trip. And what Uber would do would be to use these ratings to monitor the performance of their drivers. As I said before, if the performance of the drivers fell below a certain level, there were consequences. And ultimately, if the performance did not improve, Uber would issue warnings to the drivers. And if those weren't heeded, then Uber would terminate the relationship with that driver and no longer allow him to be a driver for them. Now, the Supreme Court said that the way that this rating system was used was very different in the way that rating systems are traditionally used on any other websites, say, for example, on Amazon or Trustpilot or any other review sites that you see, because on those websites, the customers are invited to rate products, but the reviews are used typically as a guide to aid customers. They are not used in any other way to penalize anybody or any company or stop selling products. Whereas in this case, what Uber were actually doing is using the rating system to monitor the performance of their employees, and ultimately that could lead to the termination of the contract. So they were using it as a tool for managing the performance of the drivers. Fifth and lastly, the next significant factor which the Supreme Court thought was very important and significant was the way that Uber restricted communication between the passengers and the drivers. So what Uber would do is they would restrict the communication between the passenger and driver to the minimum necessary to perform the particular trip, and Uber would take active steps to prevent drivers from actually establishing any relationship with a passenger beyond the individual ride that was given to them. So, for example, when a passenger books a ride on the app, a passenger was not offered the choice of different drivers. They were just told that the driver was coming, because the app would route the request to the driver that's available nearest to them. And once the request is accepted, then the communication between the driver and the passenger is restricted to information relating only to the ride and was channeled completely through the Uber app in a way that prevented either of them from learning each other's contact details. Also, the collection of the fares, the payment of the drivers, and the handling of complaints were all managed through by Uber in a way that was designed to avoid any direct interaction between the passenger and the driver. And drivers were specifically also prohibited by Uber from exchanging contact details with a passenger or contacting a passenger after the trip finished, unless they had to return some lost property. So what the Supreme Court did is they took all of these factors into account, and they said, well, look, we can see from taking all of this into account that the service performed by the drivers for Uber and the service offered to passengers is through the app is very tightly controlled and defined by Uber itself. And because of that, because of all of those factors, because of that amount of control, the Supreme Court found that these people that were driving for Uber were in fact workers under the law. And I come back to the word I've been using throughout all of this talk, which is about control, because a basic concept of law, employment law, when we look at employees and workers and the self-employed, one of the basic differences between the categories of status of worker can be how much control is exercised by one over the other. And generally, where you have a situation where one party exercises more control or enough control over the other party, so when an employer exercises enough control in such a way over the potential employee or the potential worker, then they are more likely to be a worker or an employee rather than a self-employed person. This is one of the basic concepts of employment law and the law of the status of the worker. So what the Supreme Court has now said is that the workers, the people driving for Uber, have all been workers for Uber, and they decided that they have been workers from the time when they switch on their app to the time when they switch off their app. And this is regardless of whether they are actually accepting rides or not, because from the moment they log into the app and switch it on, they're available to accept rides. Those rides may or may not be offered, but they are available. And the Supreme Court said that during this entire time, all the workers are entitled to the national minimum wage. So we have a potential scenario here where you could have had a driver who is logged on and available to the app for maybe 10 hours a day, and he'll be entitled to the national minimum wage for those 10 hours. If, let's say, the national minimum wage is just over £8 or £8.50 per hour at the moment, so let's say that amounts to £85 for argument's sake. If they only earned £50 or £60 in that day, then it looks like they are now going to be entitled to the difference. And these claims can go back over potentially a year or two, depending on how long the driver worked and how long they were logged in for. So the Supreme Court has now opened up what we will say is a can of worms, and Uber are looking at, particularly for their drivers, it looks like a number of drivers may well be able to now assert their basic rights and possibly even claim compensation for whatever they have lost out. Now, I say that with a word of caution. I'm not trying to encourage that there's going to be blanket claims made against Uber. Obviously, the claims have to be genuine and they have to be well thought out and quantified. But the book has been opened, the door has been left ajar, let's say, and we will see in the future what happens. But potentially, this is what Uber are now facing. Now, the decision itself also has potentially a wider impact upon other workers in the gig economy. And it may also be that there are other people working for Amazon or Deliveroo or Just Eat or other companies who find themselves in a situation very, very similar or identical to that in which the drivers in Uber found themselves in. And if that is indeed the case, if there are enough similarities between the agreements between other workers for other companies and those companies, as there was between the drivers and Uber, then undoubtedly those people may well also be workers and entitled to the national minimum wage. And if they haven't been paid the national minimum wage, then again, they may be able to make claims against those companies for compensation. So the implications potentially can be far-reaching, but it is important to emphasize that the factors I highlighted, or the Supreme Court highlighted in this case, which led them to make their decision, may not apply to every single scenario or worker who is out there. And sometimes small factors can make a big difference. And where one person may be found to be a worker, and for a small reason, another person may not be found to be a worker. But we have some daylight here. We have a decision from the Supreme Court where they said all of these people who drove for Uber are indeed workers. So it may well be others fall within the scope of this judgment. As I said in my before last week, if you have any questions, I'll be happy to answer them. Basharat, thank you very much. Over to you.
Thanks very much, Saad. That's very, very useful summary of a very important decision. Now, look, let's just try and understand this or simplify it. If each of them was an employee, a worker, sorry, then looking at the national minimum wage, to work, they'll have to tot up all of what they did earn on the app. And if they earned more than the national minimum wage, then there's no loss of earnings as a head of claim. Would that be right? So they've got to have earned less by way of the fares that they took to be able to get money from Uber for non-payment of wages.
That is indeed correct, yes.
Okay. Then let's look at the other benefits. So And there's obviously going to be harm as well, because if you're saying you are an employee, then national insurance and tax potentially comes in. And if you did not pay the right type of or class of national insurance, if you go running and say, I'm your worker, Uber can turn around and say, well, okay, let's tot everything up. How about paying the national insurance? Is that something that's likely to feature in this calculation?
But yes, indeed it can be, because obviously, Uber drivers at the moment, up until now, consider themselves as self-employed, so they were obviously required to pay tax and national insurance themselves. Now, as workers, it could be that Uber were required to pay tax and national insurance from the money that they gave to the drivers, as is the norm when you receive pay as an employee. But yes, look, what they'll have to look at is what was actually paid, compare that to what should have been paid, and if there is a shortfall between what the driver has paid, then obviously they have to be aware. They may be subject to paying more money to HMRC. But if there wasn't, then alternatively they may be entitled to claim some of their tax and national insurance back.
Okay, so it cuts both ways. In terms of holiday pay, clearly, if you're self-employed, there's no holidays. So the statutory annual requirement is 20 days plus public holidays, correct? So
that's correct. The statutory requirement is 28 days, which includes public bank holidays. That's right. Oh,
okay. So 28 days inclusive of public holidays, and we have 8 public holidays usually. So clearly, there is effectively 6 weeks nearly, working weeks, 5-day week, just 3 days short, 2 days short, sorry, which they'll be entitled to claim. Now, that clearly can't be a pick and mix. So either you are an employee and then you're subject to all of the commitments and responsibilities of an employee, and you get the benefits and you can compel Uber, or you don't, because if you were a driver, you can't say, well, I'll take the holiday pay, but I'm not going to pay the national insurance and the right class of national insurance or tax. Correct?
Yes, indeed, that is correct. And we have to be careful here in the words that we use. We're talking here about workers, not employees. Yes. So
what's the difference? Can you explain briefly what the distinction would be? It might be useful.
Yes. So the main distinction in the law is that an employee has a contract of service, so they will work for their employer. They have, after 2 years of service, the right for unfair dismissal, other rights under the Employment Rights Act, whereas workers are not employees, so they don't have rights for unfair dismissal. They won't have certain other rights under the Employment Rights Act, so they have less rights. But compare that to self-employed people who have no rights under the employment legislation, because they're naturally self-employed. So the status of a worker is somewhere in between that of the self-employed and the employee.
I mean, this potentially does have broader implications for other people who effectively have contracted to perform duties for big organizations or small, who up until now were happy in the blissful knowledge that they were self-employed and carrying on that basis. But now clearly the taxman potentially can start looking and say, hold on a second, what's going on here? And do you see any potential pitfalls for people who, unlike Mr. Aslam and co, who took on Uber, may well come out of this with a win-win, but others may well come out of this with losses, perhaps, because if the taxman sends you a letter or comes knocking on the door, so to speak, you could end up being out of pocket.
Potentially. I suppose the way of looking at it, though, is probably like this. All of the people who have so far considered themselves to be self-employed would have paid a certain amount of tax according to their incomes. Now, if they are going to make a claim against their potential employers, now that they are workers for the national minimum wage and the losses that they've incurred, then the additional amount will obviously incur a further tax liability, but that tax liability can be paid from any compensation which they are due. So it may not necessarily be that they'll have an additional tax bill which they have to foot themselves, it could come out of the compensation, and most likely probably will come out of that compensation.
Okay, so in terms of you mentioned the gig economy, this new sort of short-term, short engagements rather than the old job for life sort of arrangement that has been prevalent and is perhaps still prevalent for most. You mentioned some of the big players in this market, such as Deliveroo and what have you. What about broader than that, in terms of short-term fixed contracts? Do you think the law may affect any change in that, or do you think perhaps that's going too far?
Yeah, quite possibly. I think it is going too far. I mean, one of the what I would say the standout features of the judgment of the Supreme Court was that they didn't actually change the law when it comes to determining whether a person is self-employed or a worker or an employee. What they did is they applied it to the facts as they found it, the arrangement that Uber had set up between themselves and their drivers.
Oh, I see.
And whereas Uber were saying that, look at the written agreements that we have, we've made it clear that they are not workers and they are not employees of ours, the Supreme Court basically said that, well, hang on a minute, what you put in the written agreements doesn't necessarily tell the whole picture. And we are going to consider everything. So we're going to look at what you said in your written agreements. Well, we're also going to look at the way that you conducted everything. That's why I come back to the amount of control that Uber had over their drivers. And ultimately, the Supreme Court found that the way in which Uber had the control and exercised its control, and the amount to which it could have that control meant that these drivers were workers. So there's no... We can apply those tests across the board to any situation, and where there is that amount of control, then you're likely to be a worker or an employee rather than somebody self-employed.
Okay. Well, those who are watching, and if you know anybody else who may want to ask some questions about what this means for you or a friend, feel free to put comments and questions on the comments section. That's very interesting. So the law has been applied and found to be firmly against Uber. So anybody who wishes to enter into such arrangement, what would you suggest they do before going into this? Because clearly you need certainty before you embark on anything, whether you're an employer who's looking to take on people such as Uber did. Uber obviously must have taken legal advice, but the formula which was used to express was not good enough because nobody rigorously tested Uber and their arrangement to say, hold on a second. This is effectively what you're saying on the tin is not what we're finding in the contract. And therefore, as a consequence, this is the arrangement of a worker rather than of a standalone, conventional self-employed contractor who has a lot more flexibility and control. That's the point, right?
Yes, that's right. Yeah. And we all know that Uber, being a big multinational company, would have had lawyers drafting these contracts and agreements right at the outset to try and avoid the liability of incurring people working for them as workers or as employees. And we now know that those agreements haven't stood the test of time, let's say. So I'm sure there are other employers out there who would have tried to come up with a similar arrangement, who may now be reviewing their documentation, reviewing the way that they do things. And that is obviously a warning to a lot of employers out there. But similarly, there'll be some employers out there who have an arrangement whereby people may still be genuinely treated as self-employed.
Okay. Well, thanks very much for that, Saad. Do hang around. We've got our colleague Adnan Mahmood who's going to join us. So I'll ask you to take a well-earned break for a few moments, and I'm going to bring him on. Adnan, Assalamu alaikum, Adnan. Thanks very much for joining us.
Wa alaikum assalam. How are you?
Very well. Jazakallah khair. Shukran. Thank you very much for asking. How are you?
Alhamdulillah. Alhamdulillah. Very well.
Excellent.
Very well.
Right. Now, you're going to talk to us about buying and selling businesses because the business community is having difficulties. Businesses are struggling. There may well be many sales and people are looking to pick up bargains or buy businesses. And so it'd be useful for you to go through the process, first of all, highlight how it should work normally, and then perhaps focus on some of the key things that any person buying a business, because clearly if you're selling, you're looking to take a sharp exit, take your money and go and spend it wherever you may wish to do so. Whereas if you're buying, you're going to be left with that asset or liability. It could be a blessing or a curse. And therefore, just walk us through it, and perhaps I'll ask you further questions at the end if I need to. So it's all over to you. I'm going to take a lunch break as well, and I'll let you run with it.
Okay. Hopefully don't go too far. Right. Well, yes, inshallah, as Bashar mentioned, today I'll just touch upon what is called business acquisitions. My focus today is mainly going to be on business acquisitions for the benefit of a buyer as opposed to a seller. Inshallah, in future live shows will cover key points for which are beneficial to a seller. But for today's purposes, I'll focus mainly upon those which affect a buyer. So if you are considering purchasing or acquiring a business, an existing business, this isn't, I'm not in relation to a brand new business, but an existing business, then obviously it's very important that you do your homework. Particularly since the pandemic has hit, a lot of businesses have suffered significantly, and there's been a downturn in a lot of income. Existing business, it is extremely important that they do their homework to make sure that they are get what they are getting what it says on the tin. The consequences for someone, if you're looking to buy a business and you don't do your homework, are quite straightforward. You may end up with a business which you didn't intend to purchase. You may find, for example, that if the seller tells you that the business is turning over, say, £1 million per year, you may find that that's not actually the case, and it may be half that, for argument's sake. And if that is the case, then you're left in a situation where you've spent a lot of money in acquiring the business, only to later find that it's not actually what it was meant to be. Consequences, an analogy I'll give, it's like purchasing a car without a steering wheel. It's of no use. So it's extremely important that you do your homework properly to make sure that the business you're acquiring is fit for purpose. And that's usually when lawyers come in. Whenever you say, for example, you've agreed a deal with a potential seller to buy, let's say for argument's sake, a restaurant business, and the restaurant business, the seller tells you that the restaurant business is turning over say £500,000 a year, and it's in a good location. He tells you there's nothing wrong with the business at all. There's no debts, there's no liabilities. The business is flourishing and will only continue to flourish. If you just go on the seller's say so without doing your homework, you're treading on a very dangerous path. And what normally happens, what should happen, is that you then approach a lawyer and say, I'm looking to acquire this business. Can you please check it out for me? Make sure it does exactly what the seller is saying it does. Make sure that there's no liabilities attached to the business, and then you consider moving forward with the sale, with the purchase. So what we would do as lawyers, for example, in any business acquisition, is we carry out what's known as due diligence. Due diligence effectively means doing your homework, checking, making sure that everything is correct, that everything is pucker, everything's above board, and that all of the declarations and representations that have been made by the seller are in fact accurate. So as part of the due diligence, the kinds of steps that a lawyer would carry out is, for example, check to see whether there are any county court judgments against the existing business, because the last thing you want is to take on a business only to have bailiffs knocking on your door saying, excuse me, sir, but you owe X amount of money, or the tax man to be knocking on your door to say you owe thousands of pounds of unpaid VAT, or for you to be issued with a claim, for example, from a supplier who hasn't been paid, or even an employee who has a grievance against the company and whose grievance hasn't been properly dealt with. So as part of the due diligence, we check out, are there any county court judgments against this company? Has it ever been declared bankrupt? Are the directors, if it's a company, are they exactly the same people who are selling you the business, and do they have the power to sell? Who are the shareholders of this business, if it's a company? And what interests do they have? What powers do they have to override any decisions made by the directors of the company? If you're, for example, taking on a restaurant premises, like I said, and no doubt that restaurant premises will have the benefit of a lease, i.e. a commercial lease from where it trades from. So it's important then to make sure that does the seller have the requisite landlord's consent to make sure, the landlord's consent, which allows for him or her to sell the business onwards and assign the lease to somebody else. And does he even have the right planning permission to trade as a restaurant business? What you don't want is to acquire a business only to find out that you don't have the proper licensing in place which allows you to trade as a restaurant, whereas in fact you find out it's only got a license for example, an office or a motor repair shop. Then you'll find that you're having to make an application to the planning authorities to get a retrospective license, and there could be a risk that you may not be able to continue trading as a restaurant during that period. So these are some of the checks that would be carried out. In addition to legal checks, there's also financial checks which have to be carried out. And that's, again, to make sure that the accounts are correct. So this is not necessarily what a lawyer would do, but this is where we would urge you to get the experience of an accountant to make sure that the books tally up, that the statements made within the accounts are in fact correct, that they all tally up with the bank accounts, etc., and that it is turning over the figures which the seller is representing that it is turning over. So there's the legal checks, there's the financial checks, etc. And it's extremely important for a buyer, to ensure that these checks are done before you acquire that business. Sometimes what's also beneficial in carrying out due diligence is not only that you are sure that you're getting the right business that you need or that you think that you're acquiring, but also it can sometimes form the basis of new negotiations. So, for example, if you've already agreed a deal for, say, £500,000 to purchase a business, or whatever, could be significantly more, could be significantly less, but whatever the figure is, if you then find out that there are liabilities against the company, or it's not turning over the figures which the seller has represented, then you can then use that as a launch pad for further negotiations to renegotiate the purchase price, bring it down. Because without having that knowledge after carrying out due diligence, you're in the dark. You can't really say, oh no, bring the price down because this doesn't match up or that doesn't quite meet the books, etc. If you've done your due diligence, then and you have evidence to back up that the representations given by the seller aren't actually correct, it then allows you to then renegotiate the price and potentially get yourself a better deal. And that's what lawyers as well as accountants would help you with. So in a nutshell, that's what due diligence covers. As part of the procedure, once things are all done, then obviously there's a lot of paperwork which needs to be completed, needs to be signed off before a business actually becomes yours. And part of a lawyer's role is to ensure that all of the sale purchase agreements are correctly drafted, correctly drawn up, that they meet exactly what has been agreed by the parties, that any warranties, meaning any promises or declarations that have been made by the seller, are actually covered within that agreement, such that you would have a comeback if you later on down the line found out that there was false warranties, false representations made, etc. And then Once those agreements are agreed, signed off, approved by all the parties, then you move to what is known as completion, which is the date when the agreements are signed and the purchase monies are transferred over, and then effectively the business becomes yours. After a business is yours, there's a few more things which need to be done. For example, if you're acquiring a company, then it's important that the directorships are changed into your names, that the shareholding is transferred, that any stamp duty that is owed is paid for and dealt with directly with HMRC, etc. New suppliers are informed that you've now acquired the business, so that they know that you are now dealing with them. One important point also is that within any agreement to acquire a business, what you want is, you're not just acquiring, for example, in a restaurant, you're not just acquiring the tables and the chairs and the hob or the cooking utensils. What you're purchasing is something known as goodwill. You're purchasing the reputation of the business. You're purchasing the customers of the business. So you need to ensure, what a lawyer would ensure, is that there are what we call restrictive covenants in any sale purchase agreement, which prevents the seller from setting up a competing business, say, for example, just across the road or even next door, where he renames it similar to yours, but because he's got a reputation in the area, he then attracts all of those existing clients to the restaurant. The proper mechanisms by having correctly drafted restrictive covenants would prevent that, such that the seller doesn't set up a competing business off the back of what he's just sold on to you. So it's important, if you are thinking of acquiring a business, that you seek proper sound legal advice, you carry out proper due diligence, such that when you take a business, it's happy and plain sailing from there.
Thank you very much, Adnan, for that. I'll bring Saeed in also. Let's bring him back, and are we all there? Right. 1 second. That was that. Oh, that's very much better. Right. So, dealing with the business acquisition. Look, many people will say, if somebody's buying a business, things are a bit tough. I'm a bit cash strapped. What is it? Solicitors just pen a few lines together, sign a few documents, and charge a hell of a lot of money. I can save myself a few quid. I'll do it myself. I mean, it sounds appealing and attractive, but in your experience and in your sort of professional opinion, from what you've explained, it sounds like one of the most destructive things that you could do, unless you are professionally trained to do all of those tasks that you identified.
Correct. I mean, the famous quote, "Buyer beware." If you need to be aware of all of the risks that are involved. I've come across horror stories in my legal career where people have been told this is how much the business is going to turn over, and they take the view, you don't need lawyers, you're my friend or whatever, we're all pals, we all share and break bread together, so there's no need to instruct lawyers, we'll save a lot of money, and they move on that basis. But then what subsequently transpires is that the business is not what it was represented to be. Those relationships very quickly deteriorate between the individuals to the point that they're literally strangling each other, and the buyer is left there picking up the pieces, having been significantly out of pocket, and having to pay a lot of outgoings which were not envisaged because the seller had not represented it properly, or more importantly, the buyer hadn't done his homework. I mean, the seller's trying to bag himself a deal. What's important for the buyer is to make sure that deal is exactly what it's represented to be.
Well, this is it. I mean, I was contacted by a friend of mine, very smart, astute person, who told me a very sorry tale of people losing millions, having invested in effectively what was all singing, all dancing and glittering and shining, but in fact turned out to be a glorified scam. And very often people will use, as you said, we're buddies, we're friends, don't worry about it. So You know, I remember a friend of mine came to see me once. He goes, "Look, somebody's offered me an investment. So it's a limited company. He's given me these documents." I said, "Well, I'm not going to witness them for you, one, and I'm not advising you, but it's just a limited company. What's to say it's trading? What's to say it's profitable, as you identified?" And he was investing a serious amount of money, and he was being promised these exorbitant returns. So when I raised a few simple queries with him, he said, "I see what you mean." I said, "Yes, if you want to burn your money, then go for that." So I think the lesson from what you've said is that, look, money is very difficult to earn, very hard to acquire, and it's worth spending a few hundred or a few £1,000s, whatever, depending on the nature of the business, that you get the due diligence done, proper advice, and proper investigation, so that when you do part with tens of thousands or possibly hundreds of thousands of pounds, you're having done all of your proper checks and not relying on a friend or a buddy, because as you said, buyer beware. It's rather like turning up and seeing a car which has been very nicely polished up and cleaned up, but when you turn the key, nothing happens.
Exactly.
Right. Well, I mean, that's very helpful advice. In terms of checking out the finances, because we're solicitors, we're in the business of legal sort of checks and due diligence and compliance. How would you check the finances? And would you enlist the help of an accountant, somebody to actually carry out some sort of forensic analysis of the records of the company? Keep losing you. Now you're back. Can you hear me? Did you hear that last question?
I can hear you, but I don't know if it was my end or your end, but it kept freezing up.
Yeah, I think it may have been.
Yeah, sorry. You did you ask a question?
Yeah, the simple question was, we solicitors can do due diligence legal, so do all the relevant checks, but ultimately finances. Oh, we've lost Adnan. Maybe we'll come back. In the meantime, so I'll coming to you. I'll have to ask Adnan that question when he comes back. Just to sort of take the matter further, you mentioned the issue of the control test. Now, the control test in employment is the control test you mentioned. Adnan, give me one moment. You're back. We'll see if you can stay with the connection. We lost you. That's okay. With regard to the control test and self-employment / employment, what would you give in general advice? Clearly, people must take professional legal advice, whether they're an employee, an employer, a worker, or a company, before they enter into an arrangement. What are the key sort of things to look at? If you were to say top 3 things as an employee or as an employer to be able to work out whether or not somebody is self-employed or not?
Top 3 things, well, very, very difficult to say. What I'll say is...
Or give some examples of what is and is not, perhaps.
Fine. I mean, before I give some examples, what I will say is the control test is not the only test that is used. We do have other tests as well which are used. So don't be lulled into the full sense that it's just all about control. But the top 3 things we're looking at, I mean, look, if the prospective worker, let's call the person who's working, has enough flexibility to arrange his own affairs and do the job as he pleases, and even get somebody to do the job while he's away, you're more likely looking at being self-employed.
Right.
Whereas if somebody doesn't have control, if they're told you have to do it this way, you have to do it at this certain time, and you can only go from A to B, or you have to work only in this place, then you're looking more as the arrangement of being a worker or an employee.
Excellent. Thank you for that. So, Adnan, coming back to you before we lost you, solicitors, you mentioned the very important and numerous tasks or checks a solicitor will do to make sure that you're effectively acquiring what somebody has to sell, and on the face of it, it is something that is a viable proposition. But typically, the financial analysis, would you say that in appropriate cases, you would probably get an accountant to do due diligence? Obviously, the client must pay for that. But is it, again, worth spending that money on getting a very competent professional accountant to go through the books, critique check the bank statements and the invoices and what have you, to make sure it is, in fact, doing or turning over the amounts being set out in the representations?
Definitely. obviously a lawyer can't look over the accounts with a fine-tooth comb and understand it the way an accountant would. That's why it's
Yeah.
extremely important that an accountant who has the necessary professional skills is brought on board. I recently completed on an acquisition of a chartered surveyor's business, which had been operating across the Midlands for quite a number of years, and it was important that we had an accountant on board so that he could make sure that all of the figures as quoted on the accounts all matched up. All of the turnover figures which were represented by the seller did meet the actual accounts itself. There wasn't. He had to make sure that there was no outstanding tax liability which my client was going to assume. And only once I got the thumbs up and the green light from the accountant did we then move forward. So it's extremely important that that financial due diligence takes place.
Okay. Before we continue, I would like to apologize. Due to unforeseen circumstances, we could not. Our colleague who was going to cover the settlement under the 5 and 10 year immigration routes as a family member, we could not do that today. We will, hopefully, inshallah, we'll do it next week. So we apologize for that, even though it was on the tile, the advert that went out. At the time of recording those adverts and producing the tiles, we were in a position to do so, but intervening or supervening events have unfortunately not made that possible. We apologize for that. So going back to you, Saad, in terms of going forward, the other companies, you mentioned Amazon, you mentioned Deliveroo, and it could be any arrangement, I suppose. If somebody is considering going forward, and we covered a couple of the points already, work out how much you've actually earned. But if you've been working, you've been unfortunate where you've been on the app or whatever it might be for 12 hours a day, and you walked away with £50 or something, when in fact on a minimum wage basis in London that should be £100. What sort of figure do you think is worth pursuing through a lawyer? And would you need a lawyer? I mean, couldn't you simply write a letter and say, look, Mr. Amazon, Mr. Uber, you owe me £5,354 and 6 months of paid leave because I've been working for you for the last 10 or 12 years?
Well, I wouldn't say that it can't be done by the individuals themselves. But what I would say is that if you are thinking of making any such claim against Uber or against any other company, if you think that you can do that, it does have to be properly made. So what do we mean by properly made? First of all, you have to specifically say exactly how much you're claiming. You should explain how you've calculated that much. You also need to know how far back can you backdate your claim. So can you backdate it for a year? Can you backdate it for 2 years? Can you possibly backdate it for longer? These are things typically that a solicitor or a legal expert dealing with such claims would be able to advise you upon, will know what to do, because then once you make the claim properly to the employer, they'll be able to properly respond. And it may be that they say, okay, fine, looks like all of these calculations are correct, we will accept and concede this. Or it may be that they contest it, but at least if they contest it going forward, you know that you're on strong ground in terms of your calculations and in terms of what you're asking for.
Okay, I've got a question on the screen. Can you see it? I've listened and ascertained that the contract was vital. So ensuring a watertight contract with the clauses drawn in can vacate or go around the issue, it seems. I think just to summarize, the questioner means that if you have a watertight contract, that can potentially get around pitfalls. Well, I mean, Uber would not have drafted those contracts themselves. Clearly, they would have paid some very expensive barristers and solicitors in the city, which is Central London, shorthand for Central London, to draft those contracts. I mean, would it be fair to say you need to have an element of realism, because sometimes people can get wedded to these fancy terms that are used in contracts, but rather you've got to test it yourself. Okay, this is what I'm saying. Now let's apply what I'm saying. As you said, the Supreme Court merely applied the law. They didn't create anything new. They didn't write a new law. So the law was known, and it seems that Uber perhaps wanted to over-egg the pudding, and they were not ended up eating it much. It comes, crashing onto them. And perhaps a lawyer was being a little too, hopeful bordering on the perhaps complacent by, because ultimately when we draft contracts, we know when you're ring fencing and tying somebody into a corner, if you then think against yourself, it'd be rather not obvious, but there should be an alarm bell ringing, right?
Yes, well, look, I'll answer the question in this way, and I'm oversimplifying the matter a lot, but it's probably the best way to demonstrate the example. Now, what happened in the Uber case is that Uber had contracts between themselves and the drivers, and they had contracts between themselves and the customers.
Correct.
And effectively, what they were saying is that our contract says one thing, and that's the reality of the situation. But what the Supreme Court did is they looked at the contract and said, actually, your contract is not telling us the reality of the situation. When we look at the reality, it's something different to what the contract says. So to use a metaphor, they were trying to say that they had a spade when actually they didn't have a spade. Simple as that. They only call a spade if it looks like a spade, if it acts like a spade, if it's used like a spade. And they were trying to use a spade in the way that maybe a gun would be used, for example. Sorry to use a crude example. And that is where the problem arose. So what the Supreme Court said is that in that situation, where we don't think the contract depicts the reality of the situation, then we will look beyond the contract. We're not going to just stay in the contract and look just at that and see what it is. We're going to look at other things and make an overall decision. That's what they actually said. So it doesn't matter whether your contract is properly drafted or not. What matters actually is the reality of the situation.
This is a key point. And I think the question has put two further comments about effectively having a substitution clause allowing somebody else to perform duties. Often itself, that may not be enough if everything else points to a relationship which is the opposite. So ultimately, you need somebody to understand what you want to do and then give you frank and candid advice. There's another aspect of this question which is about retrospectively applying clauses. Now, contracts by their nature, just to put my comment on this to the person asking the question, contracts by their nature are agreed between at least two people. And therefore, you cannot impose a term retrospectively. You can amend a contract going forward. And if you're going to effectively tell an employer, look, I'm changing the terms of your contract, as an employer to an employee, what would you advise an employer who wants to take advice about amending contracts? Simply throwing a piece of paper at an employee and saying, sign it or else, or especially if somebody doesn't understand or English is not their first language, what would you say is the best practice if you're going to amend contracts of employment?
Okay. Now, in terms of amending contracts of employment, it can at times become a little bit complicated. Now, there is a general rule that any amendments to what I would call the fundamental clauses of the contract have to be done by agreement. However, some contracts will allow one party the power to amend certain terms or minor terms of the contract without getting the agreement of the other side. Whether the
what's a minor term, such as the color of your uniform or things like that? What's a minor term of the contract?
Yeah, so let's talk in real terms about pay. So the contract of employment may say when the person enters into employment, because they are 24 years old, that they'll be paid the national minimum wage, which may be, for example, £7 per hour because they're 24. Now, when they reach the age of 25, they're entitled to a higher minimum wage.
Yeah,
so
got it.
You can say then that the rate of pay is increased unilaterally by the employer because the law requires it. So it doesn't require the consent of the other side, for example. That's just an example of how to amend a term without requiring consent of both parties. But other things, for example, maybe place of work. If the contract says that the place of work is A, and then the employer wants them to work at place of work B, and that place of work may be in another city, really you're looking at doing it by agreement as to imposing it upon them. If you do try to impose terms or changes to the fundamental terms of a contract, it can give rise to a resignation being made by the employee, a potential claim for constructive.
And is it the same for workers? Because there is a distinction, as you rightly pointed out at the beginning, between doing this as between workers and as between employees?
Yeah, so, well, what we're talking here is about the general law of contract. So that will apply whether you're an employee or whether you have any other kind of contract, because these principles about amending terms by agreement are general principles which apply to contracts. So yes, I mean, even if you're a worker, you may well be able to make sure that some terms aren't changed without agreement. But because workers are in a less powerful position than employees, they may not have the ability to prevent changes to certain terms as much as employees would. It's a very, very fact-sensitive scenario. There's no one-size-fits-all solution. It's all about looking at everything in the round, and then there'll be different outcomes in different scenarios.
Understood. Well, for our questioner, this is something you will need to take advice on. The short point is it's about making sure it's done properly and fairly to avoid a future problem as an employee or as an employer. It's always worth taking that advice if you can afford it, to spend a few pounds and get a professional to look at what you propose to do before you do it. Adnan, before we close the program, a typical business acquisition, so let's say you're paying up to £100,000 for buying a business, between say 20 and £100,000 to buy something. What sort of fees would a person be looking at, excluding any accountant's fees or any disbursements, such as doing searches with Companies House or anywhere else? What sort of fees, and again, I'm not asking you to commit to something, but give it a range for relatively what you would consider a straightforward transaction, I don't know, 8 or 10 hours of work, compared to something which is complex, which could be 20 or 30 hours of work. What sort of fees between those two brackets?
Well, starting at the sort of lower end of the spectrum, if it's a very straightforward, low-value transaction which doesn't really involve a great deal of due diligence, then you'd be looking around about £1,500 plus VAT. The more complex it is, the more, for example, the more years the company's been trading, whether or not you're taking on any employees, because then there's something known as the 2-pay regulations which applies. Whether or not there are in fact any outstanding liabilities, then these kind of things, they require more careful and skillful drafting to ensure proper warranties are put in place within the actual draft.
Just explain what a warranty is, because these are jargon. This is sort of legal jargon. What's a warranty? What's a representation? Just give a simple sort of layperson's answer, if you.
Well, a representation is, for example, a statement made by someone to which they, they say it to you as if it's true. So if they say the car is red, then that's a representation they've made that the car is red. But if you subsequently find out that the car is in fact blue, either you need to get your eyes checked, or the seller's just been lying to you. In which case, obviously, that's what you look for. Then to back up any representations. What you look for is what's called a warranty, to give you the protection to say that if this representation subsequently is found to be untrue, then you have a legal remedy, a legal claim against the seller. You have a comeback, basically. You can come after him or her to say, look, that what you declared was untrue, and that's you could be entitled to some form of compensation or other remedy. Or the seller might be obliged to fix something which he falsely claimed.
Understood. There's another question which I'll answer it generically, Saad, and if in the context of employment law it's different, do tell me. The question is, can I appeal a judgment I have already appealed once? Well, the short answer is if you appealed once and won, there's no need to appeal it. And if you obviously appealed once and lost, unless you have an onward right of appeal to the Employment Appeal Tribunal or possibly on a point of law to the Court of Appeal Civil Division, the answer is no, except if you've uncovered fraud or dishonesty, which is clearly established rather than some whimsical or grievance or disagreement, then the answer is no, because the whole point of appeals are that they are final once they've been determined, unless you can show a legal reason why the decision that you wish to appeal is wrong in law. Saad, do you want to add anything to that?
No, I think you've summarized it very well. But the only thing I will say is that obviously if the person posing the question, if she's still within the time limits of appealing, then she should seek proper legal advice to see whether she's got any grounds of appeal and any merits as well.
Okay, could be a he or a she or whoever it may be. Thank you very much. Well, you put another question on, the point being, it's best to take advice on this because this could end up becoming a long evening and we're well over 10 minutes from our scheduled ending time. The question was, what about new evidence? New evidence means nothing. If you had the opportunity, you should have put all the evidence in at the time of the appeal being heard. And therefore, if you've now uncovered something, unless it shows dishonesty, fraud, something like that, in which case you may be able to try and appeal it out of time. But this will be very, very interesting and complex, and I think you can either contact Saeed at our practice, or you can take advice from somebody else. But the short point is, without looking at the determination, looking at the issues, and then looking at what the evidence is, because the evidence may be meaningless, in which case if it's new but it's irrelevant, or it's completely tangential, it's not going to make any difference. But I think you will need to take some proper advice. As always, what we've explained is for guidance purposes only. Please do not act upon what we have said and then come back to the firm to say, but you said this and I done that. It is imperative. Every case is looked at on its own merits by a professional, competent person, whether it's at Aman solicitors, advocates, or anywhere else, is not the point here. You should take good professional advice, which then would apply the law to your case. A case in point is Uber must have had very, very expensive lawyers who must have spent a lot of time, but the Supreme Court ultimately said no, because they were not potentially rigorous enough in testing their own arrangement. And hence, it's not even how much money you spent necessarily. You've got to be realistic and take advice which somebody puts to you very bluntly. And that can only be done by somebody who reads, understands, and then discusses what you wish to achieve and how you wish to achieve it. All for it to remains for me to say, first of all, is thank you very much to Saad and Adnan for taking time out to share their professional knowledge with us. And before we part company, I'm just going to play a short disclaimer out, and then we'll hopefully, inshallah, come back next week. So assalamu alaikum and goodbye from me and Saad and Adnan also. So just bear with me.